Oasis Audio presents Mere Natural Law by Hadley Arkes. Read for you by Andrés Pabon. In memory of Judy Francis son Arkes, March 4th, 1941 through November 13th, 2014. And for our granddaughter, Elena Haya Arkes. Particular intelligent beings may have laws of their own making, but they have some likewise which they have never made. Before laws were made, there were relations of possible justice. To say that there is nothing just or unjust but what is commanded by the positive laws is the same as saying that before the describing of a circle, all the radii were not equal. Montesquieu, The Spirit of the Laws. For this command which I am giving you today is not too wondrous or remote for you. It is not in the heavens that you should say, "Who will go up to the heavens to get it for us and tell us of it, that we may do it?" Nor is it across the sea that you should say, "Who will cross the sea to get it for us and tell us of it, that we may do it?" No, it is something very near to you, in your mouth and in your heart to do it. Deuteronomy chapter 30, verses 11 through 14. Forward. Michael M. Ullman on Hadley Arkes and the Natural Law. I begin with the observation that lawyers in general are an anti-philosophical race. They like their philosophy in small, easily digestible doses and tend to disdain anything that smacks of metaphysics. This disposition is partly a consequence of their day-to-day experience, which seems to be filled with infinite contingency, relieved only by the certitudes of positive law. But this feature of the legal trade has been exacerbated in every respect by a century or more of legal realism, which has trained lawyers and judges to think of law and morals as two categorically discrete subjects that must forever be kept separate. The good news is that lawyers are good at reasoning by analogy and can be taught to think syllogistically. Here is the entry point for the kind of reasoning about law that Hadley Arkes has devoted his life to explaining. Better than almost anyone else I know, he makes explicit the syllogistic structure of moral reasoning of a sort that lawyers, and for that matter, everyone else, employ all the time, the skeleton, so to speak, of their thought. Give him a couple of Aristotelian propositions, the law of non-contradiction, for example, and a sprinkling of Kant, and the next thing you know, people who have, as it were, never thought about thinking, are thinking quite explicitly, like the rational moral beings they are and have always been. The best way to instruct lawyers and judges about higher things, I think, is to stick with specific cases and hypothetical examples drawn from their actual experience. In his voluminous writings over the years, Arkes has repeatedly demonstrated an unusual, indeed brilliant knack for doing just that. He has done it again in his recent works, where he takes well-worn and familiar topics such as ex post facto laws, liberty of contract, and freedom of the press, and shows how the positive law in each instance presupposes a certain kind of moral logic that one ignores only at one's peril. Presented with concrete examples of this sort, and the list is almost infinite, lawyers and judges, whether they agree or disagree with particular policy conclusions, will feel a reassuring terra firma under their feet. They will, in short, feel at home, which is where you want them to be if you seek to energize their moral imagination. In a word, you cannot expect lawyers and judges to become moral philosophers, God forbid, but you can teach them how to reason morally, and perhaps to become confident when doing so. Beyond real and hypothetical cases, it might be instructive as well to draw out the moral suppositions that lie beneath many maxims of the common law, those dealing with the foundational principles of tort and contract, for example, or more generally, the injunction that a party seeking justice must come into court with clean hands. More general historical inquiry has a role to play here as well. Why not seek to instruct lawyers and judges about the nature of positive law reasoning before Oliver Wendell Holmes Jr. and the legal realists got hold of legal education? Along this line, the 18th and 19th centuries
Sample complete. Ready to continue?